The following program is for informational and educational purposes only. It is not to be considered legal advice. Fraudsters Radio was created to expose the many scams and frauds that have so infected society today. Scammers, fraudsters, and rip-off artists abound, whether it's scamming homeowners with bogus foreclosure relief services, dating fraud, incompetent lawyers, or consumer rip-offs. It's high time the public has a voice. If you work in a profession that deals with fraud, or if you believe you were or are a victim of fraud, you now have a radio listening public that wants to hear from you. Please feel free to message us through our Fraudsters Radio Facebook page, and we may have you on the show as a guest. If you'd like to call in for today's show, the number is 646-668-8512.
And welcome to Fraudsters Radio. I'm Laurie Z, nationally syndicated radio host and consumer advocate, with my partner, Storm Bradford, litigation consultant and owner of Mortgage Fraud Examiners. And Storm, first, welcome back to the show, because we have an exciting show today. You want to talk a little bit about it?
Yeah, we're going to have a special guest today who's an attorney who he's got a kind of a remarkable history about him. He's worked for Judicial Watch, which is which is in the news a lot these days. And the individual who had started Freedom Watch left and started another group called Freedom Watch, which has done work for them as well. But he's an appellate attorney that handles civil and criminal cases. So he's going to discuss why these so-called foreclosure defense attorneys are basically ripping off homeowners and committing malpractice, and why.
Yeah, and maybe we could do a little rehash of last week or so we've been talking about the securitization audits. So maybe explain to our listeners just briefly, again, what a securitization audit is and why it doesn't work.
Well, basically, securitization audits are, as the courts have said, the auditors are charlatans and their paperwork is empty gimmickry. Because all they basically do is take freely available information that's already on the internet and basically give it to homeowners and telling them that, well, all you have to do is that if it didn't get into the trust in time, or all these other stall arguments that have always failed, you're going to save your house, or that because the notes split from the mortgage, they can't legally foreclose, and all these other nonsensical arguments that the courts all over the country have said are nonsense. So they're just a total rip-off.
Now, I think you just posted recently, and it's something that I know someone that does this, and we've talked about it before. Explain the straw man theory, because that's one of the biggest rip-offs ever. And I know somebody who actually sells this as a service and believes it. And so, I find that frightening that people believe the straw man theory. Can you maybe explain it in layman's terms?
I can't explain it. I don't know how to explain nonsense.
Okay.
Basically, what these people are saying is that, and there's different people go about it in different ways, but basically allegedly the United States went bankrupt in 1933, which is absolute nonsense. Supposedly everybody has anywhere from 100,000 to 100 million in a treasury account, and their Social Security numbers, the account number, and that they can create these promissory notes and pay off their mortgages and cars and all this other stuff. And regrettably, people that use this go to jail in droves.
Yeah, it's sad. The person I know that does it actually sent me, and I don't remember the name of the book, but some type of a handbook. It was, when I printed it out, it was probably at least 100 pages long, explaining this straw man theory and how there's this, what I call fake money. They think of it as real money that we're all owed. And basically we're all our own corporation, so to speak. So when I read some of this, it in theory, it looks good on paper, but it's not a reality.
No, it's part of the argument is that when you're born, that your birth certificate is pledged for for collateral, which is put in this trust account for you. And not only the courts all said this is nonsense, you can go to the Treasury Department's website, you can go to the FBI's website, IRS website, and they've all discussed this before as being total nonsense. Matter of fact, years ago, there was an individual, his name was Shane Budzik, I believe was his name, and he believed in that, and he got indicted and went to court, was convicted, and while he was there, he told me, and this is how wacky these people get, he told me that a Treasury individual came in from the United States Treasury Department, an agent came in and testified in his case that, yes, that's true. Everybody does have $100 million in a Treasury account. And so when he told me that, I said, look, I don't believe that for a second. He goes, oh, no. He said he testified to that. And I said, I don't believe it. I said, send me the transcript. And he sent the transcript, which I read, and the Treasury agent, was very clear. It said, this is utter nonsense, that this doesn't exist. This is only in the figment of these, crackpots' minds. And I spoke to his standby attorney, and he basically told me the same thing. He says, this guy's whacked. Well,
I think people are so desperate. They're desperate to believe anything, and then they get a group together, and they all go, wow, this theory, it's got to be real, and so therefore it must be, and we're going to go with that. And then same thing with the securitization audits. You get a group of people who go, hey, that looks good, we're going to go for that. And so there are different groups. And the sad part, I think, is a lot of them truly believe it, and that's why they go. It's either they believe it because they want to, rather than take the reality check, right?
And Laurie, you hit the nail on the head, because see, what actually happens is that, I call them useful idiots. These are the people who parrot the lie that's been told by the scammer, and they propagate it to one another. Then all of a sudden, you have hundreds of people saying that I know this works. And then when you question them, did it work for you? Well, I didn't do it, but someone said Joe Blow did it. And it's always, somebody else was successful. And it's just, they just propagate the lies, and that's why it continues. We hear it every day on these securitization audits. People tell us, I know it works. Well, how do you know it works? Well, a friend of mine did it. So it's all just hearsay that people propagate, because the facts are, and the courts have all said, that these types of things are just scams.
Right. And one of the things I know I learned from you is whoever has the actual paper, whoever has the note, the actual paper, is the one who can foreclose. It doesn't matter how it was securitized. And so, so that I understand it, or the way I've explained it to people is, if I owed you a debt of $100 and I didn't pay you, it doesn't matter how it got 10 people down the line. You could just keep selling it off, just like original creditors do with collection agencies. As long, you know what I'm saying? So it's the same thing. And I don't know why they get stuck, how it's securitized, because in the end, it usually ends up it's been done correctly, or it's just some legal technicality. But whoever has that paper, they can foreclose, and that's what it comes down to.
Well, first of all, I've read articles that people have written before that says securitization is illegal, and they think that securitization just started in the last 10, 15 years. They've been securitizing notes in the United States since the 1700s.
Okay.
So this is not something that's new. They've been doing it forever. And to dovetail on what you said, they don't even have to hold the note. There's, I guess it's been about 5 or 6 years ago, there's a group that makes the amendments and changes to the UCC. And it's called this permanent board. And the permanent board, I think, got tired of hearing all these ridiculous arguments. So they basically did a white paper on who can foreclose. And, someone who holds the note can foreclose. People that don't hold the note can foreclose. The agents of them can foreclose. If they had the note prior, they could foreclose. I mean, there's just no way of getting around it, and it doesn't matter because you can't challenge the assignment because you're not a beneficiary of that third-party contract between the servicer and the investor.
Okay.
So every court in the country has said you can't challenge the assignment.
So in order to win on a foreclosure case, we had talked about this before, you as a homeowner would have to show that the bank breached first, some type of fraudulent inducement, correct?
Well, not only the bank. I mean, it could be some negligence on the part of the bank. It could be they breached first. It could be you were fraudulently induced by appraisal fraud, which is quite common, broker fraud, title company fraud. There are set-offs in these contracts. There are statutory regulatory mandates that sometimes aren't followed. Legal descriptions are bad. There could be all kinds of problems with these transactions, but it's the actual contract that the homeowner signed with the bank, because in that contract, the homeowner agreed that if they didn't make timely payments, that the bank could have the house. So what's the bank doing? The bank's saying, you didn't make timely payments, we're taking the house. You agreed to that.
Right.
Just like if you financed the car and didn't make timely payments, what do? They come by with the tow truck and they tow your car away. Why? Because you told them they could.
Exactly. And before we go to break, talk a little bit about your company, Mortgage Fraud Examiners, and what they do.
Well, basically what we do is we analyze the mortgage transaction from day one all the way up until today to give the homeowner the evidence that they need to use against anybody that's harmed them. Also in these contracts, there's a clause in the contract that says that if the borrower finds anything wrong with this transaction, they have to give the bank an opportunity to take, quote, corrective action. Well, the only corrective action the bank can take is to compensate you. So also the same clause says you can't even file a lawsuit or a counterclaim unless you have written that bank, which they define as a grievance letter outlining the problems so they can take action. So it's all contractual. All the courts say that these foreclosures are contractually based.
Okay, well, I can think, years back people would write those qualified written requests, and a lot of times the banks didn't even answer.
They don't have to. The only question that the bank has to answer is where did the money go? All this other stuff, was it assigned or this, that, and everything else, they don't have to answer that. That's why they don't answer them. Now, if you write in and say, look, I think there's a problem with the payments that I made or the escrow or this or that, they have to answer that by law. But all these other questions that are ancillary to that, they don't have to answer. And the courts that have ruled on it ruled that way all over the country.
Right. Now, before we go to break, I want to bring up a story I think that you know about, and I think it happened a few years ago down in the, I'm going to say Sarasota area, where some couple paid cash for a house and the bank tried to foreclose, and they actually had to go to court and had to hire an attorney because the bank was trying to foreclose on a house they paid for in cash, and ultimately they did win and they got their money back from the bank as far as legal fees. But it just says to me, what are the attorneys thinking trying to foreclose on a house that was paid for in cash? I mean, that is a really serious mistake.
Well, what you have is it's like anything else. There's negligence everywhere. There's negligence in government agencies. There's governments and corporations. There's just negligence everywhere. So, if somebody tried to foreclose, and you hear these stories, and that's what they are, is they're stories. Just earlier today, I had somebody tell me that these people own their house free and clear, and this bank came along and foreclosed on them in Florida. Now, as we know, Florida is a judicial state. You have to go to court in order to foreclose. So I said to this person, do you actually believe that somebody owned their house free and clear, they went to trial, some bank came out of the woodwork, they went to trial, and this judge allowed this bank to take this house that was owned free and clear? Do you really believe that? Because if you do, you're a moron.
Mm-hmm. Right. Well, the story I'm
true.
referencing was in the story I'm referencing was in the news. So it actually did happen. But I mean, what I'm saying is that's a big, huge series of multiple mistakes that someone within the bank should have went, whoa, we're doing something wrong here. To make it go all the way to court, you know, there was something wrong with that. But what I want to do, I want to go to a commercial break. Go ahead.
And again, I just want to say, Laurie, there's also fake news as well. I mean,
that's true.
Something like that wouldn't even go to trial, because all you'd have to do is just show that you own it free and clear. It would be on title. It would be that way. I mean, it's just utter nonsense when I hear this stuff.
Yeah. Well, let's go to a quick commercial break. If you want to call in live, the number is 646-668-8512, and we will be right back.
Have your house payments skyrocketed under an adjustable rate mortgage? Have you been laid off or had your hours cut? Are balloon payments coming due? You need help from mortgage fraud examiners. To stop the housing crisis, Congress and the White House are pinning their hopes on homeowners renegotiating their mortgages. The trouble is, the banks are saying no 80% of the time. Mortgage fraud examiners can help you get the leverage you need to turn things around. They estimate that up to 85% of all mortgages are legally deficient. Mortgage fraud examiners can perform a mortgage transaction analysis and an appraisal to find legal deficits in your mortgage. It's like CSI for your home loan. Banks and lenders suddenly start cooperating when faced with a lawsuit for violating lending laws or appraisal fraud. Find out how mortgage fraud examiners can help you. Visit Mortgage Fraud Examiners. Call 844-920-7200. That's 844-920-7200.
Okay, Laurie, we're back on, and as I said earlier, we have a special guest today, an attorney. His name is John Mosley. He's got a varied background that's quite interesting. And, John, are you there?
I hope so. Can you hear me well?
We can hear you loud and clear.
Yeah.
Why don't you tell us a little bit about your background and give our listeners an opportunity to hear that, and then we can ask you a few questions regarding these so-called foreclosure defense attorneys.
Yes, absolutely. Well, thanks a lot. I like how you say I have a varied background. Used to be called, I guess, a Renaissance man or totally unfocused, whichever, but I have done a great many things. I started out with in business with a business degree and a few years in the federal government. And then I went to law school at George Mason University here in Virginia, where I am, and found that, I felt like a lot of the government is either accounting or law, so I thought it was a good fit. And I actually just celebrated my 21st anniversary as being sworn in as a lawyer, so time flies. And in that time, I've done a great many different things as clients call for it and demand. And I've been kind of on all sides. I've been on I've done debt collection work, which didn't greatly enjoy, but it did give me a great insight into the other side of the equation when you have consumers that are facing debt collections, these various law firms that are trying to foreclose and collect and dealing with all the credit reports and various issues. In fact, one of our clients in this one law firm was SunTrust Bank, one of the big mortgage companies. So I find that it's been a great variety of useful information. I've worked for some public interest law firms too on a lot of interesting cases. Worked originally at Judicial Watch a long time ago when they were going after FBI Filegate and uncovering some of the suspicious things with campaign finance happening during the Clinton administration. And more recently, I've worked with Larry Klayman, the guy who founded Judicial Watch, in his new group, Freedom Watch, on illegal alien amnesty issues for Sheriff Joe Arpaio, appealing all the way up to the Supreme Court. I wrote a lot of the briefs for Larry Klayman, and so I've had a lot of fun doing that, but also got to, pay the bills on more normal things. The fun is fun, but people need ordinary work, and there's a lot of people. There are so many people who need legal help more than can necessarily pay for it. So that's sad, and but I have seen how rough the legal system can be, how unfair it can be, and heard a lot of complaints from a lot of people, and seen it firsthand too.
Yeah, John, you also worked on the Clive Bundy case.
Oh, that's right. Absolutely.
What happened with that? What the final outcome was with that?
Oh, that was actually amazing because Clive Bundy and his family and several hundred of his friends had a showdown in 2014 with the armed, for the Army of the Bureau of Land Management. Now, why does the Bureau of Land Management have an armed force? I don't know. Do you know that it's actually proven in very, very leading news articles that the Department of Education, where I used to work, has a small SWAT team. Like, why in the world did they do that? I don't know. But anyway, so Clive Bundy, they were trying to prosecute him for and his family, his whole family, and they put him in solitary confinement. There's a rancher. Remember, this was supposedly over collecting grazing fees. I do debt collection. You don't put debtors' prisons are not allowed. You garner someone's bank account. You don't go to all these things. So they put him in prison and in solitary confinement, leaving his wife and I think a daughter to run the family business while they were all in jail. But Larry Klayman kept pushing on the legal technicalities. He had me doing some research on it. And the judge was very hostile to Bundy, but eventually we kept just pointing out so many technical errors in the prosecution that the judge actually just dismissed charges and they didn't bring them back. I mean, there are things like we were asking for a Freedom of Information Act request about documents about the case, and in order to bring a prosecution, they're supposed to have done their homework, including because they have an obligation to provide exculpatory information. But when we're asking for copies of these documents, they say, "Oh, this will take I forget. I don't want to say the wrong number, but on the scale of 100 years to dribble out these documents." I mean, just absurd. No, yeah, something like that, like 50 months or something like that. And so that demonstrates that they didn't, they prosecuted him without, is what they admitted to do, and a whole bunch of other things that were violated. So they eventually, the corruption of the prosecution, like with the Ted Stevens case and other bad examples, forced the case to be dismissed. But it looks pretty bad for a while. So, I mean, it's just really amazing that in that environment that they weren't able to get, and they had a lot of juries actually refused to convict they had so many defendants, there were like 3 or 4 waves of them that went to trial, and the government could not get a conviction. It was just really extraordinary, because normally, they'll convict anybody. If the police officer says you did it, they'll just assume you're guilty. Anyway, so interesting times, and but I've done a fair number of credit defense and debt defense. I mean, and foreclosure defense as well. And it's a crazy situation.
So John, basically your practice now is, I mean, you've done, all this work for Judicial Watch, Freedom Watch, and trying to help the small guys, go up against the 800-pound gorilla of the government. And now there's another 800-pound gorilla. It's the banks that were foreclosing on homeowners. So, which has brought up a new set of problems for the public in general. But your practice now, Is it a little bit of everything, or what's the main focus of your practice right now?
Well, I find that, oddly, no matter what I advertise or focus on, I get all kinds of things walking in the door. So it's really kind of depending upon the people who come in. But I desire to move more into appellate work, and I've got some of that going on. But I'm really amazed at how, I don't know, word of mouth or whatever it is. It's really, I'm really amazed at the new twists and turns and surprising new cases that keep finding their way to me. It's really kind of curious. It'd be nice to just have the same kind of case all the time, but this keeps me, it kind of keeps you just when you think you've seen everything, something comes along. And it's like, oh, this is wild. There's a lot of that happening.
The lawyer. Yep. The lawyer.
Absolutely. No, absolutely. and unfortunately, some of the, that a lawyer is not allowed to trash a judge. I mean, one part of the bar rules say you're supposed to work for the improvement of the legal system, but another one says that if you impugn the integrity or the qualifications of a judge, they could take your bar license away. So it's hard for lawyers sometimes to talk about what they see, but some of it is deeply concerning. Anyway, so you've got what can you've got.
John, one other thing that I'd like to say. I mean, you just didn't fall off the apple cart. I mean, you've written briefs that have gone before the highest courts in the land, including the Supreme Court, have you not?
Yeah. Yep. Okay. And it's funny because it's all the first time you do those things, it's like pretty intimidating. But then after a few times, it's like, okay, I got this.
Yeah.
It's funny. I mean, I never would have thought at first. But go ahead.
Yeah. If somebody wanted to get hold of you, what are your coordinates and how can they get hold of us?
Well, my website's pretty simple, except there's 4 ways to spell my name. It's John with no H, just JONMOSELEY.com. Now, that's 2 E's. There's about 3 ways to spell Mosley. It's JONMOSELEY.com. And it's got all my contact information there. It's probably too wordy, but I like it. Some of my friends don't because they think I'm too wordy. But anyway, johnmosley.com, JONMOSELEY.com.
And what's a direct line to call you if one of our listeners is hold of you?
It's 703-6230.
Okay. We're going to be going to break here in a moment, aren't we? Laurie, do you have any questions for John? I'm quite familiar with his background. Do you have any questions for him?
Well, my question is, because I'm in Florida, and so, John, when the bubble burst, I've known Storm for many years now, but when the bubble burst, I got dozens and dozens of calls. The problem here in Florida, I must have contacted over 200 attorneys. Not one of them was interested in counterclaiming or any type of offensive action. They were only interested in not doing work, collecting a monthly retainer, and basically that was it at the end. It would be a short sale or a deed in lieu or cash for keys. No one and to this day have I found anyone in the area willing to take a case, where it would be, they would file first for the homeowner, or they'd be willing to counterclaim if there was some type of evidence. And so I'd love to hear your opinion on that.
Well, I think it's horrible. And there are a lot of, as strange as some things that happen in court are, there are a lot of lawyers that, there's some good lawyers. I like to think there are good witches and bad witches, but there are some horrible lawyers, and that's just scummy. Because there are a lot of people that just raked in the money, like you say, did nothing. I once worked for a credit repair company that sounds a lot like that, where all they did was take people's money. They didn't pay the debts. They waited until they got into real trouble, and then they tried to settle. But their credit was ruined, and I quit as soon as I found out the way they were handling things. And hello,
yep,
you got to watch.
Yep.
Yeah, I mean, so there are really good sounding commercials that'll get into more trouble than you're already in. That is really horrible.
Yeah, before we go to break, what you don't know is that I'm an expert in consumer credit. So I understand everything that you're talking. Yeah, and I understand everything you're talking about. Credit repair companies, they're bogus. People don't know how it works. They got sucked into the lie, and thousands of dollars later, there's nothing to show for it because they don't know how it works. And credit repair companies are not going to tell people how it works. That's how they keep you coming back. Someone like me, I actually explain to clients how it works and I teach them how to do the work, and it's all legitimate.
That's great.
And it may involve the use of attorneys, obviously in certain cases like debt harassment or TCPA. But I do want to go to a commercial break, and we'll be back when we have more to talk about, so stay with us.
All right, great. All right, thanks.
Okay.
Have you received a notice of foreclosure on your property? Do you suspect that you're involved in an unfair or fraudulent loan agreement? Are you looking for a way to save your home? Would you like to cut through all the misinformation and find out what really works? Would you like to learn strategies that the so-called gurus aren't aware of? If you answered yes to any of those questions, a professional team at Mortgage Fraud Examiners can assist you and your attorney with all of these things and more. Contract breaches, errors, statutory regulatory violations, fraudulent appraisals, and other fraudulent conduct cause most mortgages to be legally problematic. In fact, the Federal Deposit Insurance Corporation found that nearly 2,000 financial institutions they assessed received citations for significant compliance violations. They also examined appraisals and found out that of the 259 appraisals reviewed for accuracy, only 7 fully complied with professional standards. Call us at 844-920-7200. That's 844-920-7200. Mortgage Fraud Examiners, 844-920-7200.
And we're back on Fraudsters Radio. Storm Bradford, Laurie Z here with John Mosley. And we've been talking actually a lot about a lot of different things. Storm, do you have any more questions for John?
Well, and I know John knows, and any knowledgeable attorney knows that a foreclosure is nothing more than a breach of contract case, because as we've said many times, the homeowner agreed in the contract that if they failed to make timely payments, that the bank could take the house. And clearly, when you have a breach of contract case, an attorney should be reviewing that contract. And I'm sure John can dovetail on this, but the reason why they don't look at the contracts is because they don't know what even to look for. They wouldn't know if that contract had been violated, if it jumped up and bit them in the behind, because attorneys don't know how loans are underwritten, don't know the inner workings of banks, don't know if an appraisal was done properly or not. So the easiest method for them and to make money is to just stall. So what they do is we've said many times, they take an upfront fee, they take a monthly fee, and then at the end of the period of time, one of two things happen. If it's in a judicial state and the bank had all their paperwork together, the bank takes their house. If they didn't have all their paperwork together, the judge dismisses the case. But before the ink is dry on the order, the bank now has all the paperwork. They go down to the clerk's office and they refile it, and then they foreclose.
Okay, well, I'm going to jump in here.
In non-judicial states, they don't even have to go to court. All they have to do is run some ads in the newspaper, and your house is gone, again, because the contract calls for it. That's why the majority of states are non-judicial states, because the legislatures looked at it and said, look, this is basically a confessed judgment. The courts don't even need to involve the homeowner, so take the house. So that's what happened. John, would you like to dovetail on that and explain, what your background is with it and what you understand is what these foreclosures really are?
Yeah, well, there's an awful lot there to dovetail on. One thing I like from what I've seen with Norm Bradford here, I guess Storm Bradford, right? They is you focus on what works. there's a lot of things that maybe should work or you like the ideas, but just like the host was saying about credit repair, if you really know how it works and you want results, that's different. But you got to focus on what really works. Now, I've had cases where people say they really just need to stall, and they've got an explanation for why. If they just have 6 months, they can work things around. And I say, okay, I can stall for you, and I've done that. Usually, they come back 6 months later and they haven't done anything, and the stall is just a waste of, it didn't accomplish anything. But a stall can happen. Now, you're right. It is, of course, a contract, garden variety. Well, it is a real contract. I wouldn't say garden variety. Most people who've looked at their mortgage, their eyes glaze over. It's not easy to understand. They're treated differently when they really shouldn't be by the courts. But if you understand them, like Norm Bradford said, it's really important. I've had a case where after foreclosure, the foreclosure was vacated because in a private mortgage, the details were not followed, and so we were able to go to court. I got in after the foreclosure had gone through, and we were able to reverse it because exactly they did not follow, like a contract, exactly the steps that were spelled out in the mortgage or the deed of trust. In that case, I'm in a non-judicial state, which is hard because, as you said, because you don't really get your day in court unless you can figure out a way to drag it into court, as opposed to, say, Florida, where fortunately they already have to go to court, so you have more of an opportunity to file counterclaims, defenses, that sort of thing. But it is amazing in every area of life how people don't read their contracts. Now, again, reading a mortgage or deed of trust is not that easy, but people get a divorce, they don't follow it, they just put it in a drawer and then they violate it. When the contract says what to do about certain things, people don't follow it. And so it's important to look at it as a breach of contract, as a real contract. And there, of course, the bank is pursuing it that way. They may not be explaining it that way, but they're pushing the buttons for the judge that way, and that's why they're getting the results they're getting. The other thing, of course, should go without saying is everything you do here, the longer you wait, the worse it gets. It's harder to do things in a scramble than it is with plenty of time. So the other way people get into real trouble around here is around this area is that they're just procrastinating until their avenues have dried up, and that's just a shame to see that. So people need to sooner rather than later look at that thing, look at the contract, see what's going on. And
I want to jump in here, John, and ask you, a lot of people, they can read those contracts, but they're written for lawyers. They're not written for lay people to actually understand. And while most transactions are, done by the realtor being there at the closing table, I would think it would be a wise thing to have a real estate attorney review the final transaction, even if it costs more money, because otherwise there can be a pretty big mistake, right?
Absolutely. And even for lawyers, mortgages and deeds of trust are not easy to understand unless you do them a lot. And again, as Norm Bradford says, having someone familiar with underwriting standards would help a great deal. Knowing that world, a lot of contracts are like that. In fact, it's a legal principle that if there are standards in the trade, those influence what the contract actually says, what the norms are in that, what normally happens in that field. So it's really helpful to know those things.
Okay.
And it is. But what I'm saying is people really don't know when the bank didn't do what they were supposed to do and all those things. Now, I had a case where, again, I explained it to the people, and they said, no, we want said, look, we're gonna this is gonna make Mr. Bradford jump up in his seat, but we went after the fact that they didn't have the chain of custody of the note, the promissory note. And I said, like mortgage fraud examiners would say, is like, look, they're going to come up with it eventually. You're just wasting your time. But they said, oh, no, we can use, if we get a few months, we're going to turn it around, we're going to come back and everything like that. And sure enough, I challenged the fact that there was no evidence of how it got transferred to one person to another, and we went on for, I guess, about 6 months. And then, sure enough, they found it somewhere. They dug it up from some archive somewhere, and here's the transfer of the promissory note. But most people don't even know what to look for to see that they're not doing.
So how do you know that you have the right bank foreclosing? Because when you hear about the chain of title and who has the note, when a bank decides to foreclose, I mean, I've heard, but I don't know if you know any in particular. What if somebody foreclosed on me and then it turned out, or it was the wrong bank? What happens?
Well, you don't, and the court. It is sort of outrageous that the courts don't. I mean, in any other field, you couldn't get away with that. Like if I were doing that for business to business transactions, I couldn't get away with that. But somehow the courts let the banks get away with that. But if you actually force them, especially in a judicial state where you actually have to go to court, you get more opportunity to respond. They should come up with that stuff, and sometimes they can, and sometimes they can't. Traditionally, the reason for requiring the original of a promissory note, not specifically about mortgages, but about anything, is precisely to prevent somebody else from showing up later and saying, whoa, you didn't. I'm the one you should have paid, and you have to pay twice. That is a legal concept, but in the world of mortgages, the courts don't enforce that. So that's where I say, Norm Bradford mortgage.
Yeah, actually, that never happens, and here's why it wouldn't happen. And this is the argument you hear a lot of these scammers make. You don't want to be 10 years from now and some bank comes out of the woodwork and says, hey, I'm foreclosing on your home. Well, all you'd have to do is go to court. Let's pick on Chase. All you'd have to do is go to court and say, Your Honor, here's proof of all the payments that I've made to Chase in the last 10 years. Here's the proof. Chase, it's not going to happen because, number one, nobody's going to wait 10 years to foreclose on you. This is a payment that needs to be paid monthly, and if it's not paid monthly, they're coming after you. So they're not waiting 10 years in the first place. And even if this did happen in the Twilight Zone, and you prove that you made those payments for 10 years, that judge is going to turn to that bank and say, sorry, guys, you don't have a fight against the homeowner. Your fight's against Chase. So It never happens because, this stuff that they lose the paperwork and this kind of stuff, they have the paperwork, and it doesn't matter anyway because, as I've explained a million times, if Laurie, I borrowed $400,000 from you, you gave me a promissory note, you gave me a mortgage, and a month later you had a fire and the promissory note burned up and the mortgage burned up. So I read all this nonsense and I said, well, I'm not going to pay Laurie because I don't have to. She can't produce anything. Well, foreclosures are equitable proceedings. You go to court, you sue me for foreclosure, you get up and say, Your Honor, on June the 11th, 2018, I lent Storm Bradford $400,000. He gave me a promissory note. He gave me a mortgage, but it all burned up in a fire. Now, I jump up in a great Perry Mason moment and say, aha, Judge, you see, she admits she can't prove anything. Well, because it's an equitable proceeding, the court has to do what's fair. They're, in most instances, going to look at me and say, Mr. Bradford, in case you don't know what the penalty for perjury is here in the state of Florida, I'm going to tell you it's a minimum of 5 years. Now, I got a couple questions for you. Did you borrow $400,000 from this nice lady sitting over here? Yeah, Judge, yes, it did. did you, to memorialize that $400,000 loan, execute a promissory note in her favor? Yeah, Judge, yes, it did. Did you also, on the same date, as collateral for that $400,000 loan, execute a mortgage agreement? Yes, Your Honor, I did. Mr. Bradford, give her money, I'm going to give her the house. That's how it works in the real world, not in the fantasies of these scam artists and small attorneys that want to say so.
Well, that's what I want to say about mortgage fraud examiner and Storm Bradford, is that I'm impressed how you focus on if it really works. Now, Storm Bradford is willing to look at any new argument, but it better darn well work in the real world, not just, because you think it's a cool argument. And that's a lot. I heard all these arguments, and he's absolutely right, that, whatever sense they might make in the abstract, they don't work in court. So if they don't actually work in court, what's the point? Like I said, I challenged having the chain of custody of the promissory note, and they fussed and made a noise, but eventually they went back in the stacks and they found it. And so that's the reality. And
yeah. Well, let's do this.
And
let's
all
go
the
to
courts have said around the country that the chain of title doesn't mean anything anyway, because whoever has that note can foreclose. I like what one circuit court said. The 3-judge panel said, I don't care if your loan's been securitized, pasteurized, or homogenized. Whoever ends up with the note can foreclose even if it was burglarized. So, all of these things are, they're, as you said, they're abstract arguments. Most of them are schizophrenic and nonsensical. But I did have a question for you, John, that you might want to clear up for some people as well. You talked about the general run-of-the-mill type contracts. If someone came into your office with a contract dispute, which everybody that's knowledgeable in law knows that a foreclosure is a contract dispute, and you failed to examine that contract, and that individual lost their case because you failed to look at that contract to find something to help them, would you consider that to be malpractice?
Yeah, absolutely. I mean, I think there are lawyers that would be sloppy under a normal contracted situation, but it would be wrong. And I think, I think that the most important thing is to go back to basics and start with the beginning. There is a human tendency to run 5 miles down the road before you stop and figure out what you're dealing with. But the number one thing you got to do is understand exactly what you're dealing with. What does it say? What are both sides obligated to do, and what actually happened? And before you get carried away with yourself. And
right.
Absolutely, if you have a contract case, you better darn well start with the contract and with what happened under the contract.
All right, now we got to go to a quick break, but I want to continue on with that thought because I have a question for you, John. So let's do a quick commercial break and back in a moment.
All right, sure. Okay.
Okay, stay with us.
There is a very high likelihood your mortgage contains an extensive error. At Mortgage Fraud Examiners, we know just how costly a missed opportunity can be. For almost 40 years, we have consulted, retained, and referred to by attorneys, lawyers, trial practitioners throughout the nation. Put another way, we are the trusted source for litigation support. A foreclosure is basically an allegation the homeowner breached the contract by failing to make timely payments. The contract is clear. The borrower promised they would make timely payments, and if they didn't, the lender could take the property. The only way to overcome the homeowner's breach is to show the lender breached first, identify errors that would void the contract, identify regulatory violations, identify appraisal fraud and other fraudulent contact, and the only way to find these wrongs is to thoroughly examine the whole mortgage transaction. This meticulous examination of your mortgage transaction and appraisal can identify legal defects that would make your mortgage unenforceable and entitle you to compensation or even free title to your property. Call us at 844-920-7200. Mortgage Fraud Examiners, that's 844-920-7200. 844-920-7200.
Here we are. We're back on AM/FM 24/7 with our special guest, John Mosley. And Laurie, I believe you have a question for Mr. Mosley.
I do. I mentioned earlier, people here in Florida can't really find anyone to counterclaim or to do anything. But when you're talking about malpractice, what disturbs me are what are the qualifications of a foreclosure defense attorney? Because I've known a lot of them, and it seems to me they work off templates. And they all work up a set of templates to do that foreclosure, but none of them really ever have seemed to have read or understood the transaction itself. So how can they be qualified as a foreclosure defense attorney if they haven't read it and it is contract law and they don't know what's in it? That's what I find disturbing.
Yeah, I find that incomprehensible. I think that I guess when the bottom dropped out of things, it was just too easy to pick up easy money for some, I guess, for the less ethical people or whatever. But to me, no matter how similar they look at first, really every case is different. And I cannot understand how to do it as a template. I mean, you start off with certain checklists you look for, cover in each case. What actually matters maybe something that surprises you. So it does seem strange between, on the one hand, you have all these, template, mills. On the other hand, you can't find anybody to do it right. I don't understand that. It did get regulated a lot because of the abuses. Not enough, but that may have scared away the people who don't want to, who have something to protect of their reputation, I guess. But I find that hard to believe that you can't get ordinary lawyers to do more on that. That's a shame.
No, even if you look on the Florida Bar website and you look up foreclosure attorneys, a very high percentage of them, do you want to guess what their other specialty is?
No. What's that?
Bankruptcy.
Bankruptcy?
Most of the foreclosure defense attorneys are also bankruptcy attorneys, a very good portion of it when I looked up under the Florida Bar.
That's very interesting. Of course, I'm sure you and your listeners know that bankruptcy can only buy you 6 months, maybe 4 to 8 months, because ultimately that's not going to accomplish anything. Again, bankruptcy is supposed to buy people time to work things out, but in my experience, that people don't use the time well. But that's very curious that they would attract. They're probably just feeding people into the bankruptcy side of things, right, which is a profitable deal for attorneys. That's very curious.
And John, what's scary in these judicial states, and Florida is one of them, is most of these attorneys. There was no such thing as a foreclosure defense attorney 15 years ago.
Right.
They only came into existence after the housing collapse. And these attorneys were making $70,000, $80,000 a year. These foreclosure defense attorneys now, according to many people, are multi-millionaires. There's one attorney that we spoke about here a couple of weeks back in Florida who admits that all you can do is stall because he doesn't know how to analyze a transaction. He's had 7,000 homeowners as clients in the last 10 years. So you're looking at 600 to 700 cases a year that no attorney by himself can handle anyway. And
right.
He's one of the more honest ones because he admits all he does is stall, and he charges $2,500 a year. That's what he charges because he's not doing anything. But,
there are more attorneys here. Yeah, there are more attorneys here, though, that charge $1,000, or we're charging $1,000 a month on a monthly retainer, and they weren't doing any work unless they had to. So is it easy $12,000 a year for doing almost no work?
The majority of homeowners have been charged upwards of $40,000 in judicial states. But my point is, here you have one guy who freely admits that all he does is stall. He's had 7,000 clients at $2,500 a pop. That's $15 million.
Mm-hmm.
And if you take he's charging 25 years a pop, and in judicial states it normally takes a minimum of 3 years to wind its way through the court system. Here's a guy that's probably made $40 to $50 million doing nothing.
Right. But they don't seem to have to be qualified by the bar. Why doesn't the bar, if you're claiming you're a foreclosure defense attorney, aren't there CLE classes? Shouldn't there be some type of certification to make sure they actually know what they're talking about or what they're doing?
Well, the bar usually does not like to accept the idea of a specialty. They get it, but that sounds to me like it violates the bar rules on compensation, because while compensation can be all over the map, it does have, you can't charge for doing nothing or next to nothing and without violating the bar rules. So it does, I do think sometimes the bar favors those who have lots of money to throw around.
Mm-hmm.
But I find, and again, I don't want to get the idea, just because there are medical quacks doesn't mean you shouldn't go to the hospital. That's what's amazing, is there are real people with real problems, and there are real solutions, and that's why I find it amazing that these quacks have gotten away with it, when there are real lawyers who can really help somebody, and it's gotten so out of whack. I guess they've got a better.
It's easy money. Yeah, it's easy money for them, and why? And when I called, I must have called or emailed or written to over 200 attorneys, and this is a few years back. Even the ones I called, you know what they would say to me? I don't want to litigate. I don't want to go to court. I just want to be able to work from my office and file the pleadings. I've had attorneys offer to pay me referral fees, and I'm not an attorney, which is not legal. But I know that, obviously, so I don't do anything or engage in anything like that. But to say to me, I don't want to litigate, I don't want to go to court, well, are you telling that to your client? Because there's something wrong here.
Well, as I tell everyone, I mean, the best way to get a result without litigating is to be ready to litigate and win. The way you get something to your client is if the other side knows you could go to court and you could clobber them. That's when you get a good result. So it's not, you can't just say, I just want to sit at my desk. You have to be ready to go to war if you have to.
Plus, you're not going to win any case unless you have evidence against the other side. And the only way to find that evidence is to analyze that transaction. John, would you also speak on this, too? We both know this is an ethics violation, but if an attorney holds himself out as an expert in a particular field, he's supposed to know that particular field.
Absolutely, and that's why the bar doesn't like anyone calling themselves a specialist, because it implies that they've got the expertise, and they better darn well have it. That's why I can say what kind of cases I'm looking for, but I don't say I'm a specialist, because the bar, because it's false advertising unless you can back it up and prove it.
Right.
But
that's a whole other show. We have attorneys here who say they have won thousands of cases and they haven't won one. They've just stalled, and a stall for them down here is a win. And we've got about 1 minute to wrap up. John, do you want to give out your contact information one more time?
Sure. Great conversation. It's johnmosley.com, no H, short for Jonathan, JONMOSELEY.com, and it's my website. I have, my email and phone number on there. So it's easiest, just johnmosley.com. And look, great talking to you guys. It's a big topic.
Yeah, and I'd like to say that if anybody has any type of appellate work that they've lost their case, John's the guy to go to. I mean, this guy's been all over in the highest courts in the land arguing cases. He knows what needs to get done. He knows how to do it. And if you need somebody to work on your appeal, he's the guy.
And if there's a local attorney, I can do that anywhere in the country.
Oh, that's good to know. That's really good to know. Well, we want to thank you, John, for being our guest. Storm, another great show. We want to thank all of you for joining us today on Fraudsters Radio. Join us again next Monday from 1 to 2 p.m. Eastern Time live. And remember, we do want to hear your stories. You can contact us through the Fraudsters Radio Facebook page.
Bye, Laurie. Bye, John.
All right. Bye, guys.
Bye.